इस सेशन में हम थोड़ा इंटेलेक्चुअल प्रॉपर्टी राइट्स के बारे में कवर करेंगे और मैं आप लोगों को ये नोट्स भी भेज दूंगा। तो इंटेलेक्चुअल प्रॉपर्टी क्या होती है? जनरली इंटेलेक्चुअल प्रॉपर्टी में आता है कि इट रिक्वायर्स इंटेलेक्चुअल एफर्ट, या आप बोल सकते हो क्रिएटिव ह्यूमन लेबर फॉर क्रिएशन। ठीक है, तो सिंपल भाषा में बोलें तो इसमें आपका दिमाग लगता है और इंटेलेक्चुअल एफर्ट कांट बी परसीव्ड कि आपने उसके ऊपर कितना टाइम लगाया है। हो सकता है 1 मिनट लगाया हो सकता है 20 साल लगाए हो, 30 साल लगाए हो। वो आपके दिमाग का एफर्ट है, इट कांट बी परसीव्ड, एंड बिकॉज ऑफ दैट आईपी इज इंटेंजिबल। ठीक है, इंटेंजिबल मीन्स दैट देर इज नो फिजिकल एक्सटेंट of intellectual property in space. So what that means is, by your intellectual effort, you came up with some invention. uh, Let us say you wrote a book, but even behind writing one page of that book, there was a lot of thought process. So even though you can touch the paper of the book, but you cannot touch the thought process behind that. So the intellectual effort is actually intangible. There is no physical extent in space, but even with that, IP is capable of being described. So you came up with a new invention and you can still describe it. Okay, so although it is intangible because of intellectual effort involved, it can still be described. And generally IP can be replicated easily, like movies or software. Somebody may take years to write a software, but it can be replicated very easily. Okay, so those are some aspects of intellectual property. Now, intellectual property rights are rights for protection of intangible property. Okay, just like we have rights for protection of tangible property. Let us say you have a house or a plot of land, then we go for registration of the house or plot. Okay, so then there is a paperwork involved that the property belongs to you and you have some right over that property. Okay, similarly, rights are required for protection of intangible property, and those are called intellectual property rights. And IP rights become official by the process of registration. Okay, just like we register land, depending on what type of intellectual property we are dealing with, the rights become official when we go through the process of registration. And these IP rights, they include actually groups of rights depending on the subject matter or depending on the intellectual property. So these are some of those. So for example, if you came up with by your intellectual effort, you came up with some artistic work. Let us say you created a painting, or you wrote a drama, or you created some music. So that is sort of artistic work, or some literary expression. You wrote a book, things like that. So if this is the subject matter, then for protection of our intellectual property, there is copyright. Okay. If the subject matter is aesthetic design means that it just looks good. Okay, that's all. It may not have, it should not have any functional value. Okay, for example, you came up with new design of a computer monitor, which looks very appealing, very good. Okay, so that will be called an aesthetic design. And for protection of that, there is industrial design, right? Okay. Similarly, if the subject matter is that we are dealing with what is called geographical indication, what that means is specific characteristics due to specific geographical origin. For example, there is Darjeeling tea. Okay, Darjeeling tea, it is not that any tea is Darjeeling tea, but tea that originates in Darjeeling that has some special characteristics due to their origin being in Darjeeling. Okay, so then naturally it should not be allowed that any tea grower can use the label Darjeeling tea. That should not be allowed. Okay, so for protection of that, for protection of this specific geographical origin of the product, there is this geographical indication right. Okay, and for protection of symbol to identify a business, there is trademark, and for some technical invention, there is patent right. Okay, so these are some categories of intellectual property rights. Now we will go through all of these very briefly in the following. So when we say copyright, copyright basically, you must have seen that letter C written at many places in books and in thesis also, C inside a circle. So that is for copyright. It protects creative work, literary or artistic work. And if you go by the formal definition, a copyright protects original work of authorship, including literary, dramatic, musical, and artistic work such as poetry, novels, movies, songs, computer software, architecture, all these things. And once you have a copyright of your original work, then you only have the right to publish, perform, and record that subject matter. Okay, and if someone else takes a copy of your work and starts replicating it, okay, then you can go to the court and prevent that person from doing that, because that intellectual property, that artistic work is belongs to you. Okay, now the general rule is that copyright lasts for 60 years, and but within that there are some categories. In the case of original literary, dramatic, musical, and artistic work, the 60-year period is counted from the year following the death of the author. Okay, so it is not counted from the date of copyright or from the date of creation of the work, but you can say death of the author plus 60 years. So that is the life of the copyright. But in the case of cinematograph films, sound recordings, photographs, posthumous publication, all these things, uh, and there are some other categories also, the 60-year period is counted from the date of publication. Okay, so that is copyright. Now coming to industrial design. Industrial design is for protection of visually appealing work. Okay, that's all. It looks good. It has no functional value. For example, let us say some company comes up with some fancy design of shoes which just look good, but don't have any functional value as such. Then they can protect that design by registering industrial design. Okay, but if the design has some functional value, let us say the functional value could be that it allows shoes to breathe more, so you don't feel that much sweat. Okay, then it has some functional value, then it will not come in the category of industrial design, because apart from aesthetic appeal, it has some functional value. So then it will be called more like a technical invention, and it will go in the category of patent. So industrial design is only for visually appealing work. Okay, and industrial design, it can include three-dimensional features such as the shape of an article, or two-dimensional features such as patterns, lines, color, all those things. And it is applicable to many items. For example, even chair, you can come up with a fancy design of chair which looks good, fancy design of table or lights or shoes, automobile body. Like for example, Coke bottle, actually its design is uh, uh, has been it was registered, that shape of the Coke bottle. uh, and industrial design registration, it gives the right to prevent third parties from making, selling, or importing articles bearing or embodying a design which is a copy or substantially a copy of the protected design, when such acts are undertaken for commercial purposes. So the idea is that once you have industrial design registered, then any third party cannot like make, sell, or import a, a copy of that design or substantially similar design without your permission. Okay, so that is industrial design. Now, geographical indication. Geographical indication is a sign used on products that have a specific geographical origin and possess qualities or a reputation that are due to that origin. So previously I gave you example of Darjeeling tea. So the tea possesses certain qualities which are due to their being grown in Darjeeling. Okay, so then there is an intangible, intellectual property associated with that tea, and you can, for that tea which is grown in Darjeeling, you can get a geographical indication. And what that means is, okay, on the next point you will see here, a geographical indication right enables those who have the right to use the indication to prevent its use by a third party whose product does not conform to the applicable standards. So what that means is, once you have the GI right for something, then you can use that GI, that indication on your product, and you can prevent any third party who does not have that right from using the same GI on their product. So if I'm growing a tea in Dehradun and on that I write Darjeeling tea, okay, then you can go to the court and you can prevent me from doing that. Okay, so that is geographical indication. And geographical indications are typically used for agricultural products, foodstuffs, like for rasgulla. Actually, I think there is a GI for Odisha and also for Bengal, okay, for rasgulla, because the way they make those rasgullas, there is something special in those rasgullas due to the place. And some wines and spirits, handicraft items, some industrial products. So, uh, so the GI right can be obtained for those if they have some specific characteristics due to the origin of the item from a particular place. Okay, that is GI. Now, trademark, uh, they uh, actually it protects symbols or words that act as a source or indicator of goods or services. So various companies, they use some symbols, some marks. Okay, and just by looking at that symbol, that the source of this particular item is this company. Okay, uh, so some points on this are, these marks, they could be some symbols, some words, they are used by businesses to identify their business. Like Nike has some symbol, some tick mark. Any company, Toyota will have some symbol. So those symbols are trademarks. Okay, and these marks, they become a symbol of quality or reputation, and these symbols themselves, they become a valuable asset. And consumers differentiate competitive products by these symbols, and these trademarks can actually become a cult. Like somebody will say, I only drive Toyota cars, or I only buy Apple products, something like that. So it becomes important to protect these symbols and words, which are called trademarks, and that is done by registration. So trademark registration will confer an exclusive right to the use of the registered trademark. So once you have registered it, only you can use it, no one else can use it. The trademark can be exclusively used by its owner or licensed to another party for use in return for payment. Okay, so it will prevent others from using that symbol or that mark or that particular word which you are using to identify your business, which your consumers are using to identify you. Okay, and the term of the TM registration is usually for 10 years, and it can be renewed indefinitely on payment of additional fees. And trademark can be a combination of words, letters, numerals, drawings, symbols, some three-dimensional features such as the shape and packaging of goods, and they can also include non-visible signs such as sound or fragrance. Like if you know Netflix or other companies also, they have some sound. You hear that sound and immediately you identify, okay, this is the sound of uh, Netflix. You identify that particular business with that sound. So even sound and fragrance can be trademarks, or they could even be some color shades which are used as distinguishing features. Okay, so the whole idea is to have some symbol, some drawing, some words which you use to identify your business and your customers use to identify you, and then it becomes important that you prevent others from using that particular symbol. Okay, so that is trademark. Okay, now patents. uh, Patents are for protection of technological invention, and which is a product or a process. The invention can be a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. Okay, so it is a technological invention. You have come up with a new product or a new process. Let us say you came up with a new product, some new chemical, some new material, some new polymer, some new uh, process for making some chemicals. So those things, those can be patented, the technological invention. And the patent owner has the exclusive right to prevent or stop others from commercially exploiting the patented invention. Okay. In other words, patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others without the patent owner's consent. Okay. The system for patent worldwide is, for getting patent, is first to file system and not first to invent system. Okay, let us say that you invent someone but you don't file for a patent, and then somebody invented the same thing after you and he filed it. Okay, so then he will get the patent, not you. So filing is important, not just invention. And who can file for patent? It can be true or first inventor. So basically the scientist. It can be an individual or a team. It can be assignee of the true inventor. By assignee, what it means is basically the employer. Like for example, if I am a scientist and I am working in a company, then I don't own that invention, although I did it, but I don't own it, but the company owns that. So company is the assignee to which that invention has been assigned by the true inventor. So the assignee can file patent, or it can be filed by a legal representative of a deceased person. Okay. And patents are territorial rights. In general, the exclusive rights are only applicable in the country or region in which a patent has been filed and granted in accordance with the law of that country or region. What that means is, if I got a patent in India, then that patent right is applicable only in India. It is not applicable outside India. If you get a Chinese patent, it will be applicable only in China. Okay, so these are territorial rights. At present, you cannot obtain a universal world patent or international patent. Okay, there is no such thing as international patent. A patent is granted by a national patent office. Like for Indian patent, there will be Indian Patent Office who will grant the patent which is applicable to India. Or in some cases, there are also regional offices that carries out the task for a number of countries. So just for example, say 5 or 10 countries come together and they have a regional office. So if you get a patent through that, then that patent will be applicable to all those countries. Okay, so you can get a national patent or a regional patent, but there is no such thing as an international patent. The protection in patent is granted for a limited period, generally 20 years from the filing date of the application. Okay, and you can also license a patent, and licensing a patent means that the patent owner grants permission to another individual or organization to make, use, sell, etc. The patented invention. Okay, so it can be licensed. Now let us see what are the conditions for getting a patent. The first thing is novelty. It has to be new, and some new characteristic which is not known in the body of existing knowledge in its technical field. Okay, the body of existing knowledge in the technical field is called prior art. So novelty means it has to be different from prior art. That is one condition. Another condition is the invention must involve an inventive step or non-obvious. Okay, which means that it could not be obviously deduced by a person having ordinary skill in the relevant technical field. Okay, so even if it is novel, it has some new characteristic, but that new characteristic, if it is very obvious to a person who has ordinary skill in that area, then it won't be called an invention. It will be just a very obvious thing. Okay, so there has to be an inventive step. Another requirement is the invention must be capable of industrial application. uh, it it means that it should be beyond some theoretical phenomena. Okay, it should be capable of industrial application, and the subject matter must be patentable under law. So I already told that patents are territorial rights. So if you are applying for an Indian patent, then the subject matter, let us say it is some agricultural patent or related to pharmaceuticals, then the subject matter of that patent, it must be patentable under Indian patent law. Okay, and these patent laws, they vary from country to country. And another requirement is the invention must be disclosed in an application in a manner sufficiently clear and complete to enable it to be replicated by a person with an ordinary level of skill in the relevant technical field. Okay, so when you are applying for a patent, actually the requirement is you have to disclose it. So you cannot say that I am going to keep it secret. Okay, then there is no patent. So you have to disclose it, and disclose it sufficiently clearly and completely, so that another person with an ordinary level of skill in that area, he can replicate what you are disclosing. Okay, so these are the conditions for getting a patent. So when you file a patent application, then certain things are required. I have listed only a few of those. There will be some title of the patent. You have to specify what is the technical field of this patent. You have to describe the invention, its features, the status before invention, and the claims. Okay, claims means the matter for which patent protection is sought. Okay, so the claims are the most important part, and uh, so in claims portion you will specify that this specifically, that this is what is new. Okay, for which you can say you are taking the credit and you are taking the protection, that this is my invention and others cannot use it without my consent. So you will get protection for the claims that you are making uh, in the application. So this is the most important part of that. And patents are granted by patent offices. in exchange for a full disclosure of the invention. I already told you, you cannot keep it secret. And in general, the details of the invention are published and made available to the public at large. So when you file a patent application, there is a timeline. At some point, the your application will be published and it will be available for people to see. So it won't be secret anymore. Okay. Now, let us go through the process of patent prosecution in India. So prosecution basically means this process of publication of the patent, then its examination, then grant. Okay, once you file your patent application, then up to a certain point it is kept confidential, and then it is published. So it is open to public, and even people from outside, they can read your uh, patent, and they can object that the claims that you have made in that are not new. Okay, so all that process of opposition is also there, and the patent office is going to examine your application and claims, all those things. And uh, after examination, they will grant the patent or they will refuse it. Okay, so this whole process is called patent prosecution. So let us go through the process in India for this. Okay, now let me just increase. Okay, so here it says stages and deadlines for patent prosecution in India. And here it gives you actually four types of applications: a provisional application, PCT application. Actually, it says conventional application. It should not be conventional application. It should be convention application and ordinary application.